Hi, my name is Moses Ehimoson. Today, I'll be responding to one of the questions asked by some of our friends and clients. And the question is, Mr. Moses, please, I want to know and understand the essential lands document. So today's talk is titled Understanding the Essential Land Documents. Now, before speaking on this essential land document, let's quickly look at land classification. Now, land can be classified as either free or acquired. A parcel of land is considered free if the government has not indicated any interest whatsoever in that land. Such land is safe to buy because the title on that land can be perfected without issue. In most cases, such land will either have a gazette, a COO, or government consent. Now that you understand what it means for land to be free, you should also know that all lands that fall within areas that are designated as urban areas are under government acquisition until deemed committed or free. According to the Land Use Act of 1978, all land belongs to government until deemed free. Now, there are two types of acquisition. We have committed acquisition. We have global or general acquisition. Now, committed acquisition. A parcel of land is said to be under committed acquisition when the government has indicated an intention to use that land for a specific purpose, such as provision of amenities. Such land belongs to government and can never be available for use by individuals. If you purchase land that is under committed acquisition, it will be impossible for you to perfect your land title, and you will only be occupying the land until government comes to kick you out. Now, global or general acquisition. Land that are under general acquisition or global acquisition can later be confirmed free or committed, as the case may be. A land under general acquisition can become free by a process called excision. Now, excision is a process whereby the government releases a portion of an expanse of land that is not committed. If a parcel of land that was formerly under acquisition becomes excised, it is then considered free and becomes gazette. The gazette then becomes the title on the land, and such land is safe to buy because a proper title can be processed on the land. Now that you understand the classification of land, let's now look at the meaning of each land document. That is survey plan, excision, gazette, certificate of occupancy, governor's consent, deed of assignment, one after the other. Survey plan. Now, the best way to know whether a land is under acquisition or free is to get a surveyor to chart the site and take it to the Surveyor General's office to do a land information to confirm whether it falls within the gazette and spell out which particular location it can be found. A survey plan is a document that measures the boundary of a parcel of land to give an accurate measurement and description of that land. The people that handle survey issues are surveyors, and they are regulated by the Office of the Surveyor General in Lagos as it relates to survey issue in Lagos. A survey plan must contain the following information: the name of the owner of the land surveyed, the address or description of the land surveyed, the size of the land surveyed, the drawn out portion of the land survey and mapped out on the survey plan document, the beacon number, the surveyor who drew up the survey plan and the date it was drawn up, a stamp showing the land is either free from government acquisition or not. Now let's look at excision. An excision means basically taking a part from a whole, and that part that has been excised will be recorded and documented in the official government gazette of that state. In other words, not having an excision means the land could be seized by the government anytime without compensating you, even if you bought it legitimately from the buyer or the original dweller on the land. Now, gazette. A gazette is an official record book where special government details are spelled out, detailed and recorded. A gazette will show the communities or villages that have been granted excision and the number of hectares of land that the government has given to them. It is within those excised hectares that the traditional family is entitled to sell to the public, and not anything outside those hectares of land given or excised to them. A gazette is a very powerful instrument the community owns and can replace a certificate of occupancy to grant title to the villagers. A community owning a gazette can only sell land to an individual within those land that have been excised to them, and the community or family head of that land has a right to sign your document for you if you purchase land within those excised acres or hectares of land. If the government, based on some reason best known to them, decide to revoke or acquire your land, you will be entitled to compensation as long as it is within the excised land given to that community. Now let me give typical example of relationship between excision and gazette. Illustration where Victoria Island, Ikoyi and Lekki were all part of one big community joined together and called Oniru, and it had no separation to know which area is called Ikoyi, Lekki or VI then, and it has an approximate total area square meters estimate of 100,000 square meters, and the government is interested in that area and decided to take 70,000 square meters from itself for its own personal use as an urban area or public purpose. It will record this acquisition in the official government journal, which is called Gazette, and also record that the remaining 30,000 square meters excised portion has been left alone for the traditional family to have and do with it whatever it pleases it to do. This is a good illustration of the relationship between a land under acquisition and excision and gazette. Now, certificate of occupancy. A certificate of occupancy, COO. Lagos State Government officially lists Lagos land to you or the applicant for 99 years because as all land belongs to governor's consent. So many academicians, lawyers and intellectuals have tried to define what governor consent is, and they end up confusing simple-minded men like me with their big grammar. So I'm going to attempt to do the impossible by breaking it down and how it operates under the law. A simple formula to follow is this: the first person on a virgin land that has neither been occupied, neither by another person, nor under acquisition by the government is entitled to get a certificate of occupancy on that land. Now, if that person with C of O decide to sell his land to another person after so many years, that person must now obtain the consent of the governor before the transaction can be deemed legal in the eyes of the government. If the new buyer now decides to sell the land again to a third owner in future, that third owner must also obtain a new consent of the governor before that transaction can be deemed legal in the eyes of the government, and the process continues every time the property changes hands to a new buyer. In other words, the first person on a land is the only person or group of persons entitled to obtain a certificate of occupancy. Every subsequent buyer of that land must get a governor's consent. There can only be one owner of that certificate of occupancy on that land, and it will not be replicated for another person once the land has been sold or transferred to another person. Now, the power of the governor to consent to such transaction can be found in Section 22 of the Land Use Act in 1978 as amended. I quote, "It shall not be lawful for the holder of a statutory right of occupancy granted by the governor to alienate his right of occupancy or any part of thereof by assignment, mortgage, and transfer of possession, subleased or otherwise howsoever, without the consent of the governor first had and obtained." Now, with this power, the governor has the right to grant consent to any transaction which he thinks has not contravened any law of the land, and if the consent has been obtained fraudulently, the governor is entitled to revoke such consent immediately. It is very important for a purchaser of land to perfect his or her document by obtaining a governor consent so as to have a complete rest of mind. Although it is good to buy a land that already has a global COO or the land has a gazette, it still doesn't give you the full satisfaction that you own the land without any form of fear or intrusion by the commonwealth, because your documents have not been perfected and the consent of the governor to that transaction has not been obtained. Deed of assignment. Most people fail to ask for the deed of assignment to their properties, which is several times more valuable than cash that you put the title document intact in a safe place. A deed of assignment is one of the transactional documents drawn up by a real estate attorney between the current title holder for a particular property and the new buyer. In real property transactions, a deed of assignment is a legal document that transfers the interest of the owner of that interest to the person to whom it is assigned. The assignee, when ownership is transferred, the deed of assignment shows the new legal owner of the property. The deed contains very pertinent information for a real estate transaction. It spells out the date when the ownership of the property transferred from one owner to the other. The deed also gives a specific description of the property that is included in the transfer of the ownership. It is very compulsory and mandatory for a deed of assignment document to be recorded at the appropriate land registry to show legal evidence as to the exchange of ownership in any landed property transaction, in order to make the general public and government aware of such exchange or transaction. Any recorded deed of assignment at the appropriate land registry will be authenticated in form of either a governor's consent or a registered conveyance after it has been stamped at the stamp duties office. It is important to know that the deed of assignment document is not the only document indicating transfer of ownership. The following document are usually involved when your purchase is made. The purchase receipt, the contract of sales, the deed of assignment, the survey plan, the building plan for housing investment, any other title document that may apply. Now, each of these documents can come at separate times in the transaction process. The seller signs all the documents when the transaction is complete and hands over the document to the buyer. Now, don't forget to hit my subscribe button and turn on the notification bell for more videos. And please, you can drop your question on the comment box. We'll be delighted to respond to them all. Thank you.